Hello, this is Rick Durfee and Mike Koberlein with Durfee Law Group for Compliance in the Age of Homeland Security. What every real estate agent needs to know about estate planning, asset protection, and charitable planning. Welcome. It's exciting to have you here. We're going to have a good time today. Hopefully, we can answer some questions and help you be prepared for things that are going to come up. And I want you to know that we have a chat box open, and we will keep that open. We want questions as we go. We want to be very responsive to what you want to know about all along. So if we need to cover something in more detail, or if we've talked about something too much and you want us to shut up and move on, just shoot us a message in that chat and we will be responsive. We're going to try and cover all the things that were listed in the brochure that many of you got: wills and powers of attorney, revocable trusts, irrevocable trusts, charitable remainder trusts, asset protection, charitable planning, tax reduction strategies, and complex multi-party planning. Say hi, Mike.
Hi, how are you guys doing? Hopefully everyone's in that wants to be in. I don't know if George is in on this or not. It's like he might be waiting. And in response to Mara's question, yes, we can record and we are recording. So certainly have this available after this show.
And let me point out this too. We're figuring this out, I will acknowledge. So you can see us, I think. Let's see if you can see us here. We'll say hi. Maybe you can't. I don't know. Anyway, we will resume the share. Okay. First of all, we have to tell you that nothing we say today can be used to lie, cheat, or steal with the IRS. If you use anything we give you to try and escape your lawful obligation to pay taxes or help your client do so, you're screwed. Don't do that. We have to say that. So why the heck focus on all this stuff that we're going to talk about? And there's three big, huge reasons.
One is to attract and keep more clients. Two is to focus on high net worth and high income clients. And three is to better serve clients' needs.
And of course, the last one is, if you don't know this stuff, you're going to mess up your clients. And I guess the point here also is your competition is out there and they're smart and they learn some of this stuff and they know and understand the needs of their clients and they know how to address those needs. One of the things we've seen with professional advisors in the real estate arena, and frankly in other arenas as well, is if you can be the concierge, people view you as the person to come to when they need a referral, when they need a solution. I've got this going on or that going on. Then they are able to, well, they'll come to you and they'll ask you for questions. I want to make sure we let everybody in this thing that needs to be in. I think we're all in as far as I can tell. Mm-hmm. Okay, so if you don't do this, your competition is going to do it. So here we go. Next. We're going to start by talking about a trust. And this is kind of some entry-level estate planning stuff. If you're in real estate, you're going to be dealing with trusts. You got to know what they are. You got to know how they work, why people have them. And in simple terms, a trust is a contract that controls assets or property over time. So people have this to do lots of things. One is to avoid probate, which we're going to talk about some more later. Another is to, there's some tax issues that can be managed through a trust. And the third and huge one is a trust can be a succession device that plans and protects assets over multiple generations. So as a contract that controls assets over time, a trust has three parties. That's why when we diagram or illustrate a trust, we use triangle to describe that. So the first party in the trust is a grantor. The second party is the trustee. And the third party is the beneficiary. So the grantor is the person who creates the trust. Trustee is the executive that administers the trust, and the beneficiary is the person who gets the benefit of the trust. And then the trust, of course, has to own assets. And a trust can be revocable. It can be irrevocable. And there's some pretty significant differences between those two. Most of the time, most people dealing in the real estate industry, the trust you're going to encounter is going to be a revocable trust, sometimes called a revocable living trust. These are the trusts that are the engine that drive estate planning in the United States. They're pretty popular. Having said that, it's actually astonishing how many people don't have one. And here's just kind of a rule of thumb as you're going out there and dealing with this. Either your clients have a trust or they don't have a trust. Either their assets, their real estate is owned by a trust or it's not. Just saying, those that don't have a trust should have one. And those that have one but don't have their real estate owned in it are messing it up. They're screwing it up. They're not getting the benefit of the trust that they paid money for. So one of the things that you as a real estate professional can do to help your clients is to be aware of the fact that, again, they either have a trust or they should have one. If they don't have one, help them get one. If they've got one, help them make sure that their real estate is titled in the name of their trust. And if you encounter situations where, well, they're going to ask questions like your clients are going to ask, well, if my real estate is owned by my trust, can I sell it? Can I rent it? Can I give it to my daughter? Can I do all these things? And the answer is, oh yeah, of course. The trust does not alter your ability to manage or work with or sell or buy the real estate. Another question that commonly comes up with real estate owned by a trust is, can we get financing on it? Can we get a loan on it? And there's some nuances here that real estate professionals really need to be aware of. It used to be, and this tells my age, decades ago, there were no banks anywhere that would ever loan money on real estate owned by a trust. So we always had to get the financing before we put the real estate in the trust. Today, I don't know, it's some ratio. Some banks will, some won't. I just negotiated and helped a client get a loan this last week on a multi-million-dollar property in another state that was owned by a trust, and it worked just fine. But sometimes if the lender freaks out or doesn't understand it, and there are a few out there that still will, it's okay on a new purchase or even a refi to have title of the property in the client's name individually, get the loan on it, and as soon as the loan is in place, then deed it to the trust. And for you real estate professionals, I want to add a little tag on how we deed real estate to a trust. A lot of people, especially people who don't understand the consequences of deeds and titles, will use a quit claim deed to convey property to a trust, and that is a bad idea. It is better to use a special warranty deed. And I'm not going to go into the nuances of what's the difference, but bottom line is you're warranting that you actually have title and that it's going in the trust. And the reason for that is the special warranty deed keeps the benefits of your title insurance and doesn't create a hiatus that sometimes title insurers get their tail in a knot over. So special warranty deed that property to the trust. If there's a financing issue, it can be owned in the grantor's name right here. If you can see my little mouse going around the grantor can own it. After the finance is in place, they can deed it to the trust or to the trustee for the benefit of the beneficiaries. Also, if real estate is owned by the trust and people are trying to refinance it, they can take it out of the trust, refinance it, and then they need to put it back in the trust. So trusts can be revocable or irrevocable, and they can be single-use trusts or they can be trusts that last a long time. And we want to kind of just run through some things to be aware of in trusts, and I don't want to spend a lot of time. Trusts can be thin or fat. If you see a short trust that's just a dozen pages or even 50 pages, there's going to be a lot of tools that it could use that it probably doesn't have. Trust has to be funded. The assets have to actually be handed or transferred to the trust. A trust can be a device for preventing and avoiding litigation. And in fact, if you ask people, what's the most important thing in your family as assets transition from one generation to the next, people will tell you, I don't want my family members fighting about it. Having said that, how many estates actually end up in litigation over who gets the stuff? And the answer tracks pretty close to what happens with divorces. About half of marriages end in divorce. About half of family estates end up in some kind of a dispute. A trust can have spendthrift clause, which means that the assets in a trust can, under certain circumstances, be protected from the liabilities of not mom and dad, but their children or their grandchildren. Now, to get that spendthrift protection, in most cases, you have to die. And it's been my experience that my clients prefer to avoid that. So death is not a good price to pay for asset protection. But if you're going to be handing assets to the next generation, you may want them to have that benefit. And for that to work, distributions have to be discretionary, not age-based. You'll see a lot of trusts that say, well, give the money to my child when they turn age, whatever. And that can clobber the spendthrift clause. We've seen a lot of cases where, because of mandatory age-based distribution, you had a birthday, the trust is compelled to distribute the money, it comes out of the trust, and now your creditors take it all. So we can protect the corpus, the trust can have a protector, and it can be multi-generational. I don't want to spend a lot of time on this because there's some other cool stuff we want to get to. But another huge thing is, well, I had a trust in the state where I used to live, and now I live in Arizona. Do I have to update it? And the answer to that is, it depends. And if you happen to be looking at the trust or talking to somebody about it, here's what you look for. Most trusts are written by lawyers in their local jurisdiction for people that live within 5 to 10 miles of their office, and they're only thinking about local law. They're not thinking about what happens if my client moves to another place. Because the nature of our practice, we have clients in all 50 states. We deal with a lot of multi-state issues. We deal a lot with people who live in one place and own property in another place. So we build our trusts so that they're not dependent on any single jurisdiction, and they can move with you. If you live here today and somewhere else tomorrow, you can take it with you. So sometimes that's an issue. People moving into Arizona from another place, they very well may need to update or upgrade that trust so that it's not dependent upon wherever it is they moved from and works here. And let's see here. And trust, by the way, can implement a family's values, the things that are really important to them, and can help the family focus on what matters most, which is not always the money. Do I need a trust? We have a handout or a worksheet, a tool that people can go through to help them figure out if they need a trust. And that's something that we give away out for free. So if you're wondering, gee, does my client need a trust and how do I figure it out? Call or email our office and we'll give you that Do I Need a Trust worksheet to help figure that out. And I want to add that here too. As professionals working out there in the world, we are a resource. You can call us, you can email us. If you have a question, you can ask us, and we will work with you. We will, within reason, not charge you. What we hope to get out of that is that we can help you. If we help you succeed and help you take good care of your clients, not all of your clients, but there will be one or two here and there now and then that will come and work with us. So, oh my, this all came on at once. Well, we're going to transition now. Here we go. Yeah, that was it all came at once. One of the things we're going to look at with these trusts and with business entities and asset protection and all the other stuff is people often have entities. They'll have different kinds of companies, and often those companies own the real estate or control the real estate or involved in it. And I wanted to have this list here of leaning your ladder on the wrong wall. It's a good ladder, perfectly good ladder. You can climb on this ladder, but it's leaning on the wrong wall, so you're going to get in trouble. There's some very specific things to be aware of in owning a business. And big number one at the top of the list is no one should ever own anything personally, ever, in my opinion, with maybe rare exceptions. So what are the alternatives to owning it in person or personally? What's going to be owned by something else, a trust or something else? Oh, got to admit people here, admit and admit. I'm learning how to use this. I would expect people to just come in automatically, and there's probably a setting that I needed to do so that doesn't happen. So if somebody's out there waiting and you see them waiting, holler at us with a text or something and we'll let them in. So things should not be owned personally. They should be owned by a trust or some other ways. Now, there are some alternatives to trusts specifically that avoid probate, and there's a couple of them on here. One is the joint tenancy, and the other one is a beneficiary deed. And as real estate professionals, you deal with these all the time, and it's critical that you understand the difference, and I encounter people who don't. So we're going to spend a few minutes talking about this. With joint tenancy, whoever's named as a joint tenant, they have a present interest in that property. They own some part of it now. And with joint tenancy with rights of survivorship, the last one standing gets it all. So if you have 3 siblings, for example, that own the family cabin in joint tenancy and one of them dies, the dead one's out and the survivors own it. And this can work. This can work in the right situation. Sometimes with parent-child, it can work. It can avoid probate. However, I have seen situations where a mother puts her house in joint tenancy with her daughter. Her daughter incurs debts and financial liabilities and has to file bankruptcy. The daughter has to list, yes, I own a piece of that property. And anyway, it gets entangled and encumbered and creates lots of problems for the mom. So joint tenancy can work in the right circumstances, but it can also blow up in your face. Beneficiary deeds, I'm sure you're familiar with these. They're a new invention. It's a device that names a beneficiary that does not own a present interest, but will own a future interest in the property once the owner passes away. And that too, for smaller, simpler estates, can be a device that helps avoid probate and passes the assets to the next generation. Another subtle tax issue is with joint tenancy. If you are a joint tenant and you receive interest in a property because the other joint tenants died, you have a carry forward cost basis. So if the property cost 100 and now it's worth 300 and you have some built-in gain, and we're going to talk about this in a little bit here, that gain is yours and you're going to pay taxes on it. If, however, you obtain title to a property by virtue of a beneficiary deed, you get a step up in cost basis so you can sell that property and not trigger the capital gains tax. You will see people that have sole proprietorships, general partnerships, by the way, which means general liability. You are liable for everything, and corporations and LLCs. I want to focus for a few comments here, and we're going to go into more depth on this on LLCs. LLCs are a relatively new device. I've been doing this long enough. I remember when they did not exist. One of the cool things with LLCs is you can elect how they are taxed. They can be taxed as a partnership, as an S Corp, as a C Corp, or disregarded. And there are some significant consequences to that we want to talk through, including whether or not that LLC is actually effective at protecting your assets. You will also see people say, oh, I've protected my assets because I put title to my rental properties in the name of my beloved family member or my trusted high school friend. And then the beloved family member, the trusted friend, has troubles of their own and ends up having some kind of liability attached to the property, and it gets in trouble. It's also, when we're doing asset protection, which we're going to talk about a little bit more here, just having a trust doesn't cut it. And if your trust is a single use, we're going to use it once and then throw it away, that too does not create any kind of protection for future generations. And then people often are concerned, especially in large estates, and what constitutes a large estate has changed significantly. That used to be, the number used to be $600,000, which was pretty easy to hit if you owned a home and had a life insurance policy and a little retirement account. Today, large, at least for federal estate tax purposes, is more than $11.5 million. So that's very few people. I will observe, though, that as a real estate professional, you want as many of those people with $11 million as you possibly can get as clients, either as selling properties or buying properties or investing in properties. So you want to understand what their needs and concerns are. And often they're concerned about, how do we give our stuff away to avoid the estate taxes without giving up control? And that's something we can help them figure out. Okay, next. Want to talk about LLCs in some more depth because people screw them up all the time. And don't you like this guy standing on that ladder there? Ladders are a perfectly good tool. They help us reach things we can't otherwise reach, but we can use them in a way that's just catastrophically dangerous. And frankly, the same is true with LLCs and limited partnerships. And I'm going to just hit some of these things because you encounter this all the time. All the time you are dealing with people who own real estate and it's owned in an LLC. And this person will proudly tell you how smart they are because they've protected their assets because it's owned by an LLC. And the thing you got to know is LLCs get clobbered every day in the civil courts and in the bankruptcy courts, and they get clobbered for some of the reasons we're going to hit on right here. One is LLCs should never have natural persons as the members or as the owners. Who should be the owner of the LLC? Well, at a minimum, it should be the trust. Why? Because if you personally own the LLC, it can subject that LLC to probate in the event of your death. It can create succession issues. And natural people, hey, guess what? Natural people die. They become incapacitated. They get sued. They get married. Lots of things happen to natural people that don't happen to trusts. All those things that can happen to a natural person can create problems and issues for the company. So by having it owned by a trust or by another entity can alleviate some of those things. So this now is a big one. How do people screw up their LLCs so that they can get clobbered? And the answer is by having just one member. And how many, what's the percentage or what's the ratio of LLCs that have a single member instead of multiple members? And the answer is most of them, almost all of them. And why do they do that? Often the LLCs are set up not by lawyers, or even if they are set up by lawyers, not by anybody who knows what they're doing. They're set up to be simple for tax reporting purposes. Single member LLCs have the advantage, I guess, of being disregarded for income tax purposes. So the owner, the member, is going to pick up all the income tax consequences for that LLC on their personal tax return. It'll typically come on Schedule C, sometimes another schedule depending on the nature of the assets or the business, but typically on Schedule C. So let's see, wait, all of those business activities are now reported on our personal tax return, which you can go figure are having business activities on your personal tax return a red flag for auditors? I think they are. But here's the other big deal. Single member LLCs are readily, quickly, and easily clobbered in the courts. If you try to protect yourself from liability with the single member LLC or the stuff in the LLC from your personal liability, the courts are going to say, well, hey, you're the only member. Why can't we clobber this? In bankruptcy, for example, the bankruptcy trustee will say, yeah, I get it. Just make me the manager of the LLC. And then they scoop out all the stuff out of the LLC, throw it into the bankruptcy court and take it. So one of the things that we look for when we review LLCs, when people say, yeah, I want this LLC to protect my stuff, is does it have more than one member? And if we're going to have more than one member, who should the members be? Me and my children? Well, those are natural people. So maybe it should be my trust and another trust or another LLC or something else. So there's some things like that. We see a ton of LLCs that are what I call naked. They have no operating agreements, no evidence of membership, no governing documents of any kind, which once again, that opens the door for them to be clobbered. And I want to hit here for just a second. A lot of people have corporations. We don't do as many corporations as we used to in the 80s and the 90s, largely because there are LLCs. In Arizona, LLCs are across the board a better deal than a corporation, even if you want the tax treatment of a corporation. So people say, well, wait, I want to be taxed as an S Corp. How do I do that? Well, you can still do that with an LLC. You just elect to be taxed as an S Corp. But three big, huge reasons why using an LLC taxed as a corporation is better than just using an LLC. Number one, corporations in Arizona and in virtually every other state have to file annual reports. If they don't file an annual report and pay a fee to the Corporation Commission, they are administratively dissolved, and then the business entity and its protection all goes away. It's gone, lost. Corporations, by law, are required to have annual meetings and record those meetings in minutes. And if you don't, you have carved a hole in the corporate veil and allow the bad guys to get through it to attach the assets. Reason number 3, stock in a corporation is personal property and it is subject to garnishment. So if you own shares of a corporation and you get sued and a judgment is levied against you, and the judgment creditor comes to collect your assets, they'll say, do you own any corporations? And you'll say, yes, I have this corporation and here's my shares. And they'll say, thank you, I'm taking them from you. And now those shares of the corporation belong to the judgment creditor and not to you. With an LLC, properly structured, especially if it is a multi-member LLC and a manager-managed LLC, none of these things apply. LLCs in Arizona don't have to file annual reports. They're not required to do minutes. And the assets in the LLC are not subject to garnishment. So do we have a question about that? Okay. If we do, we'll answer that as we go.
Well, Rick, I actually had a question about that. When you mentioned that the LLC, if you have an operating agreement and you have certificates of membership, things that would document the business, how is that something that protects or helps businesses if they're sued?
Great question. One of the things that happens when a business gets sued is the plaintiff subpoenas all the business records. And they're going to say, prove that you're a business, that you're actually functioning as a business, that it's not just you or your alter ego, that this LLC isn't just a sham. And one of the factors that they look at to determine that is, do you have an operating agreement? And if you don't, just merely the absence of an operating agreement is evidence that, hey, this is not a real LLC. This is a phony LLC. It's just your alter ego. So we're going to allow the creditors to ignore it or get through it or bypass it. But then even in the LLC operating agreement itself, provisions can be built into that which make it really difficult or expensive or unattractive for someone to try and penetrate it. So, for example, you can have requirements about who can be a manager and who can't be a manager, who can be a member and who can't be a member, how new members come in or how members get out, whether people can sell their membership interest. And all of those provisions built into the operating agreement affect how much or how little a hostile party is going to be able to penetrate that LLC and get in and grab its stuff. And incidentally, there are one of the things we do, because we have clients all over the country, is we shop jurisdictions. Where's the best place for an LLC? Should I have a Nevada LLC or a Delaware LLC or a Wyoming LLC or Alaska or Arizona? And just for the record, Arizona is in the top 5 or 6 best places in the world to have an LLC. Arizona has a really good LLC law and really good provisions for LLC. So we're a good place, but sometimes people want to go someplace else. There are some states that have more or less statutes that fill in the blanks. If your operating agreement is silent, then the statute dictates what's going to happen. And Arizona is one of those, by the way. There's a whole lot of, if your operating agreement is silent, there's a statutory presumption of, well, this is what's going to happen. So it's far better to have an operating agreement where you pick what's going to happen instead of leaving what's going to happen up to the politicians, which makes the LLC vulnerable to the winds of politics when they change, or the politicians think they have a good idea because some emergency prompted a change in the law. You don't want your company to be vulnerable to that. You want to have your own provisions built in to the LLC. I hope I answered that.
Yeah, no, you did. Thank you very much.
So when we do asset protection, and this is a biggie, people will come and say, oh, I want to protect my assets. I want to be judgment proof. I want to control everything and own nothing. And which is cool. We love that. That's how we make a living, is helping people do that. But there are some costs to doing that. And these costs have to be weighed against the benefits. And I want to hit all 3 of these. The first cost is, whoa, back, where do we go? Here we go. Oh yeah, setup. There we go. Cost number 1, setup, maintenance, and complexity. So setting up a vigorous asset protection plan, it costs money. You're going to pay the lawyer a lot. Then the maintenance cost is, sadly, the lawyer doesn't get paid on that. Usually the CPA gets paid on that. When you create an asset protection plan, you're going to go from however many tax returns you have now to more. We often add a lot of tax returns potentially, depending on how complex or big the plan is. And the third one is complexity. Every asset protection plan is, by its nature, complicated. And people say, well, I don't want it to be complicated. I want it to be simple. And sadly, this is one of those life choices. You can have simple and no protection, or complicated with protection, and it's your call. Which one do you want? And some people, when they see that, and I try to make people aware of this up front, will say, yeah, that's so complicated, it's not worth it. I'd rather face the risk than have to live with that complexity, which I'd rather have people figure that out before they set up a big complicated structure than after. So having said that, we want to look now and we want to examine, whoa, I don't know how that happened. There we go. Okay. This is a sample of what an asset protection structure might look like. I hope everybody can see this screen. And this includes a number of things that are basic to estate planning. And in fact, up in the upper left-hand corner, you'll see some documents there called basic documents. And Mike's going to walk through and explain those, because this is a fundamental, the basis or the foundation upon which all the rest of the planning has to build.
Yeah, so thank you, Rick. This will be something that you'll want to talk with each of your clients about and make sure that they have these basic documents, what we refer to as basic documents or basic emergency documents. The first one is a last will and testament, or a will. And essentially a will is got two purposes. One is to transfer what you own to your beneficiaries. And the second purpose is to name guardians. So if you have a client who has children and they don't have a will, then they don't have a plan for their children if they were to pass away and there's nobody there to look after their kids. So in the will, you can name who takes care of and watches over your children. The same is true if you have a responsibility for adults who lack capacity. The other documents are called powers of attorney.
So Michael, when you have a trust, what's the beneficiary of the will?
So if you have all of the basic documents and you have a trust as well, then what the way that the will operates is what's called a pour over will, and it won't transfer any of your assets. That's not really the purpose of it. It's really to point into the direction of the trust and pour over anything that's not in the trust, telling the court that it's your intention that everything was what should have been in the trust, but if you leave something out by accident or otherwise, then the will tells the courts that those assets should have been in the trust. And you may hear sometimes that if you have a trust that you're going to completely avoid probate. Well, that's only if you have all of your assets funding the trust, what we call funding the trust, or named in the trust. If you have a trust and you have assets that would trigger probate, then this is helpful, even though you would go to probate, because it tells the judge, hey, I want all of my assets to go into my trust. And so it's a little more of a seamless transition when it comes to if you have a trust and you have a pour over will, as opposed to there being some kind of confusion about where those assets should go. Did I answer that?
Yeah, thank you. Good.
So the other documents are medical power of attorney and a living will. Those are two documents that are related to healthcare. The main difference between those two documents is that the medical power of attorney is for issues where you might, they're temporary, but you're incapacitated, and so you can't make decisions on your own. So you have designated or appointed an agent to do it in your place. The living will, however, is different because it's an end-of-life document, meaning you're going to die, and these are the people you would appoint individuals to be able to have the power to make decisions on your behalf, knowing that the end is near. And the last document is the general power of attorney or durable power of attorney, and this is for situations for your financial decision making. So if you are out of the country and you can't make decisions regarding your finances, then you can have somebody who's your general power of attorney who can make those decisions for you. Keep in mind that these documents, these powers of attorney, are only applicable and they're only operable when the individual who created them is alive. The power of attorney goes away once they pass away. The will does not, but the powers of attorney do.
Awesome. So those documents function in correlation with the trust, and you'll see, like we did before, the trusts are represented by triangles. There's a blue one, which is a revocable trust, and there's a green one down here, and I'm going to tell you why we have that green one. But in general, and by the way, we create these kind of diagrams for our clients. We map out their family, we map out their advisors. You'll see up here at the top, it says real estate advisor. We would be thrilled to have your name in that box as the advisor on the advisory team for the client, so that when the client has a real estate issue, we know, oh, it's you that we call, because real estate issues happen. When the client says, hey, I'm going to sell my home, I say, oh, well, you're going to go back and work with so-and-so, right? Because we'll have that on our diagram. But the revocable trust, this blue one here, is included in the taxable estate of the client, and it's also available to their creditors. In general, you can't create a trust that where you put your own assets in the trust and then your assets are protected from your creditors. That's called a self-settled trust. And there are some states that have attempted to pass laws that allow that. In fact, you'll hear something called an asset protection trust. And just saying, in the bankruptcy court, there's a 10-year look back. If you created one of those for 10 years, they can just ignore it and pretend like it doesn't exist. And other states just flat out refuse to ignore it or refuse to honor it. So it's always ignored. So I really do not like or favor asset protection trusts unless you live in a state that allows that. You have all of your assets are located in that state, and you're never going to go anywhere or do anything outside that state. And it might work under those circumstances, but even then, there's better options. So this trust has to own your personal assets, and you'll see your bank accounts, you'll see your personal residence listed there, and you'll see we've got a little green check mark that it should be deeded in, and we'll note when that property was deeded in. And incidentally, that's something you can help the client with, and frequently we need to involve you. When we are forming business entities, and you'll see 3 of them here, one with property in it, a limited partnership, and a management company. We'll talk about those briefly here. Remember, to be protected, those entities need more than one member. And we don't want that member to be a person. So where do we get the second member? And that's this green trust right down here. This is an irrevocable trust, which, by the way, means unavailable to creditors. It does not mean unchangeable. So they can still be changed. There's just ways you have to do it. Typically, mom and dad here create this trust, but they're not the trustees and they're not the beneficiaries. The children and the grandchildren are the beneficiaries. So this trust is below the generation line and outside the taxable estate, and importantly, unavailable to the creditors. So now we want to talk about this limited partnership here, this family bank. And this could be an LLC, the same principles apply. And I want to tell you a story, a historical story that relates big time to these limited partnerships and why we use them and why it's important to have that limited. Limited partnerships were invented in England. And there was a really interesting historical event that triggered their invention. Prior to the invention of the limited partnerships, all partnerships were general. And the partners had general liability. So if the partnership had a loss, the partners could be compelled to put in money to cover that loss. Well, there was an English partnership that funded a shipment of certain goods that were being imported from India to the colonies. And the colonists were not happy about certain laws. And so a group of them showed up in the middle of the night, dressed up in disguises, and threw that cargo over the side of the ship into the Boston harbor. And as a consequence, all of those partners had general liability and were compelled to put more money into the partnership to pay for all that tea that ended up in the harbor. So they said, hey, let's allow partners to limit their liability so that they only have at risk whatever they put in. So if they put in a certain amount of money, that's it. Your risk is limited to that. You could lose that, but you can't be compelled to put in more. So limited partnerships have two kinds of partners. Limited partners whose liability is limited and who by law have no control, and general partners who have general liability, just like the Boston Tea Party, but they also have control. So if you want control, you're going to have liability. You want no liability, you give up control. That's the limited partnership model. Now, for this to work for asset protection, we need more than one partner. So who are the partners? You can see our little colored lines here. One partner, follow the blue line back over here, comes back over to the revocable trust. Mom and dad own some of that. One partner, follow the green line, comes right down here. It's the irrevocable trust. We get that interest down there by a gift or by a contribution. There's a variety of ways that can happen. But we want that irrevocable trust to own a fractional share of that limited partnership. What about the general partner where there's liability? With a limited partnership model, we want that general partnership interest to be owned by another entity we call the family office or the management company. We'll talk about that in a second. But by virtue of having these multiple partners in that limited partnership, it makes it so that an outside third-party creditor cannot penetrate that partnership and take the assets away. They do have some remedies, but they're limited and they're specific, and we can use this device to insulate the business assets from the liabilities of the individual partners to it. We use this management company, this family office, as the general partner to contain that liability. So if there's liability that gets out of the partnership, we don't want it to come over personally to mom and dad here. We want that contained, so that goes to the management company. And then if there's rental properties or apartment buildings or the shopping center, there will often be a string of subsidiary LLCs that will own a particular building or a particular property. So particularly, you'll see people out there that are flipping real estate, that are accumulating rental properties, that have a string of commercial properties. They'll have LLC after LLC after LLC after LLC. Now, the people who do it poorly, who have bad advice or who are doing it themselves, you'll see that they'll own all those LLCs personally, which sabotages the protection and makes them awkward and difficult to deal with. And a plan that's well organized, all those LLCs owning all those various properties will be owned by a parent entity, the family bank, and fractionally owned by a third party like this irrevocable trust, so that we get several benefits: consolidated ownership, economies of scale, the risk management. We get involvement of future generations in the wealth. We get some tax planning options. There's just a ton of things that happen as a result of this. Not everybody needs this much planning. We just wanted to show you this as an example of the kind of planning that can be done. And if you're involved with a client who's working this and your name appears up there as the real estate advisor, very often you're going to be working with a client and say, hey, they're buying a new property. How do we structure this? And the answer is going to be, oh, we have a template for this. We're going to form a new subsidiary LLC, just like this orange one here, owned fractionally in the way we show, controlled by the management company. And so we'll whip that together so that that new entity can take title to the real estate. I want to kind of move on here.
If I could just interject real quick,
Oh, yeah.
Rick, I know we at the beginning said that any of you out there who have questions, certainly feel free while we're moving through to ask any questions that you have. You can go ahead and we have a chat available. So if you want to put your questions there, we'd be glad to answer them as we go through.
And I want to say, are we ending it at 11? Because we have like 4 hours worth of material here. We might have to talk fast.
No, it's at 10 to 12.
So. Okay, so we can keep going. So we make this point several times. Tactics is climbing the ladder in the right way. Strategy is putting your ladder on the right wall. And we want to talk about what some of this might mean. With Dynasty Trust, and the family office and the family bank and then the family foundation that you saw, these are 4 general types or kinds of structures, principles that we use. Not everybody ends up with all of them, but they each have a function, and it's beneficial for you to be aware of these because you're going to see them, and people either have them or they need them. Typically in the Dynasty Trust, we're going to deal with who gets what, and we're going to do the estate planning. In the family office, we're going to focus control. We're going to run the business. We're going to create jobs for family members. And we do a ton of tax planning. And by the way, we create tax deductions. The family bank is where we hold all the goodies. This is where we're going to have the rental properties or the subsidiary entities. We get protection here. We can have loans to family members. By the way, especially with people that have money and that are building money multi-generationally. Rather than giving money to their kids, they're going to loan it to their kids, and they're going to take security for it like any other bank, and they're going to do that through structures like we've shown you here, and then the subsidiaries. I put the family foundation on here for a couple of reasons, and we might spend a little more time on this. Often there are events that arise where people own things that they think belong to them, and they really don't. They're going to have to give them up. And it's going to go to one of 2 places, or maybe one of 3. Sometimes they can get it to their children. Sometimes that's an option. I don't get to keep this, but I can get it to my children. Another option is I don't get to keep this, but I can let the politicians have it because they're going to confiscate it in some kind of tax scenario. And the third option is, well, I can't get it to my kids, and I don't want it to go to the politicians in taxes, but I can give it to charity. And if you're going to give it to charity, it might as well be a charity that you have some influence over so that you can pick the charitable causes and the charitable missions and the charitable things that get supported. So that's the purpose for the family foundation. And that is sometimes called social capital. And we capture money that it would otherwise be lost and taken by the politicians, and then we can implement our family values. And by the way, that becomes a very powerful succession next generation training vehicle to help upcoming generations figure out how to use money and how to not be dirty, rotten, deadbeat trust babies that do stupid things with the money. So, sorry, was that a little over the top? Yeah. So here, here's this. Yeah. Yeah. That's calling people names. Sorry. So having the right entity with the right structure, we've kind of hit on some of this before, but I want to talk about some of this again real briefly. With a family bank, it's got to have multiple members. It's going to be managed by a third party. Sometimes you'll hear people say, well, should I go offshore? And the answer is maybe. We do a fair amount of offshore planning, and sometimes it makes sense, and sometimes it just absolutely does not. I will tell you that for every 1 person we take offshore, we bring 2 or 3 back because it's expensive and complicated, and there are domestic solutions that often work as well, if not better, and certainly with a lot lower cost. Another thing that you'll see with this family bank, I know I'm not hitting all these bullets, but down here, this note and mortgage on the residence. When we have a complex structure like that one we showed you on the big diagram, often people will have a lot of equity in their house, and they'll say, well, I want to protect the equity in my house from the bad guys. How can I do that? And one of the ways we do that is we set up a mortgage, and the lender is not a commercial third-party provider. The lender is the family entity, the family bank. And the lender, we set up a line of credit, a commercial promissory revolving credit line note, so the balance, like a credit card, could be zero, or it could be whatever the credit limit is. And that mortgage is secured by a deed of trust or a mortgage on the residence. So now the family bank, a friendly entity, is in priority position as a secured creditor ahead of all the other ahead of all the other bad guys. So if there is a meltdown situation, that equity can be recovered. Some lawyers call that an equity strip. It may or may not strip the equity out depending on what's going on with that loan. But in any event, it's an extremely powerful device to protect equity. So if you have a client who says, yeah, wow, I own my home free and clear, I want to protect the equity in it, is there a way to do that? The answer is there is. And I also want to say, for all of you real estate professionals out there, some of you I know are old like me and have seen a lot of things happen, but some of you are younger. Those of us who lived through 2000, 2007 and 8 in the real estate crisis here, I'll just tell you that in my neighborhood, 40 or 50% of the houses changed hands. The people that were living there don't live there anymore. They lost their house. And one example, I had a neighbor who owned his house free and clear. He'd lived there for 25 years and was very proud of the fact that he'd paid off his home. But he felt bad because he saw all of his friends making millions of dollars by investing in real estate. So he took out a big fat mortgage on his house and went and bought a series of rental properties, all of which were highly leveraged. And then 2008 happened, and it was like dominoes, plink, 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 plink. He lost those rentals one at a time. When the income went away, he lost the ability to make the mortgage payments on his personal residence. Plink, he lost his house. Now, today, another very nice family lives in that house. But that guy who lost his home is pretty sad. So people will ask me as a lawyer, should I pay off my house or should I invest the money somewhere? And I know there's a lot of people who say, oh, you can use that money and it can make more money for you somewhere else. But my life experience and professional experience tells me, man, you pay off your house, good for you, pay it off. We might want to protect it with that note and mortgage, the equity strip strategy. But keep that house paid off. So we want to move into another area here, and I want to introduce a topic. In fact, I wish I had this in another, well, we'll come to this. So people understand tax deferred, and the subtle difference between tax deferred and tax exempt is often lost on people. People, in fact, say, oh, my IRA is tax exempt, and it's not. It's not tax exempt, it's tax deferred. There's going to be a tax someday, just not this day, but there will be one. But there are some things that are in fact tax exempt, which means no tax, doesn't pay a tax. So when we have highly appreciated assets with built-in gain, and we're going to talk about this, I'm going to have another slide that shows this, there's a tax. Well, what if we could have absolutely no capital gains tax and get a big fat tax deduction and have tax advantaged income for life and tax-free money for our heirs and fund our charitable intent. And it all happens in this mysterious black box here. Oh, do we care what's in the black box? And some people do care. Some people, it freaks them out. They see the black box and they go, oh no, not that. But here's the deal. Here's what's in the black box. Charity and life insurance. So if you, in your real estate transactions, can creatively use some charitable and life insurance planning, you can help your client get all these advantages. No capital gains tax on the sale of appreciated assets, tax deductions, tax advantage income. We take care of the heirs and they fund their charitable intent. So let's look at how this happens. And to illustrate this, I want to kind of walk through what capital gains tax is. And I think most people get this, but I'm surprised at how many people, even if they understood it once, it's kind of slipped to their mind, and a refresher kind of helps them re-understand. So when we buy a piece of real estate, we have a cost. Sometimes it's called our basis. And maybe some of you can remember this. It used to be that you could buy a piece of property at a low value, and over time it would go up in value. It would appreciate in value. That used to happen a lot. It still happens sometimes after various market crashes, and I've lived long enough to live through several of them. That doesn't always work that way. But in any event, that appreciation, the increase in price or value from the cost, is called the capital gain, and that's taxable. And that tax is deferred. There's very special rates. Those rates go up and down. They are vulnerable to the political process. Depends on who's in control. And there will be a taxable event. And the good news with real estate particularly is you are in control of when that taxable event happens. And when's it going to happen? Typically when you sell the property. And oh, by the way, that tax is voluntary. You don't have to pay it. What? Can I not pay taxes on my capital gains? Now, real estate professionals, you all know this, and it's kind of a powerful and popular idea for good reasons. It's a very, very useful tool. You're all familiar with the 1031 exchange. Now, is the 1031 exchange tax deferred or tax exempt? And the answer is tax deferred. There's still a tax. We're just kicking the tax down the road. We're going to show you a tax exempt way of doing this. And this is with something called a split interest gift. Now, y'all in real estate know that when you have an asset, you can split it up in a whole lot of ways. You can build a fence down the middle of it. You can have tenants in common where you each own an undivided interest. You can lease it where it's, I own it, but you get to pretend like you're the owner for the next 3 years during the term of the lease. Well, another way to split up property is in its income interest, its present income interest, and its future residual interest at the end of the term, either when you die or a term of years. And you can keep one of those and give one of them to charity. And typically in this model, you're going to keep the income interest for the rest of your life. Now, it doesn't have to be for life. It can be a term of years, but in this model, it's going to be for life. And the residue is going to go to charity when you die. And if it's going to go to charity anyway, once again, we want that to go to your foundation. And there's some very inexpensive and fun ways to create a family foundation. We might spend some more time on that. But here's, by the way, this can be a trust or it can be a gift annuity. But the most common form is the trust, largely, especially with younger people, because the trust, although there's ongoing obligations like filing tax returns and doing accounting, you have a little more control. But if you're older and you just want mailbox money where you don't have to worry about it, then the annuity approach works. So with this device, you can sell that real estate by gifting it to the charitable remainder trust. You get a tax deduction for the gift. The trust sells it. There's no tax on the capital gains. The trust invests the proceeds, pays you an income for life, which is offset by all those deductions. You take some of that income and you use a private contractual alternative to purchase life insurance for the benefit of your heirs. That green triangle should be familiar. And then when you die, the balance goes to your foundation. So let's look at how this works. If we're going to assume a net 5% income, a zero cost basis, 20% federal tax, 6% state tax, and a 3.8% affordable tax. We can all afford that, right? That's what the politicians named it. So if you have no CRT and you sell $1 million property, with our assumptions, you're going to pay just a little less than $300,000 in taxes. You don't get any tax deductions. You net $700,000 and change. That is going to produce a $35,000 a year income. You're not spending anything on insurance premiums, and over 20 years, you're going to make back your $700,000. You're going to spend your $700,000. When you die, we're going to assume again an estate tax. So in this scenario, you would be over the estate tax threshold, which again is a moving line, but today's 11 million. And so your heirs in this scenario net $330,000 and change, and charity gets nothing. With a CRT, you have the same $1 million property, you gift it to the CRT, right immediately you get a tax deduction not for the full $1 million, but only for the 300 grand, because you didn't gift the entire property. You only gifted the residue when you died. And that number, by the way, goes up the older you are. The older you are, the bigger that deduction. So when you sell the property, you net the $1 million. There's no tax. So your income is, in this scenario, $15,000 a year higher. You have a bigger income. Use a part of that extra income to pay premiums on that life insurance. Your net income is $800,000 instead of $200,000. You spend it. When you die, there's no estate taxes here, and your heirs net $1 million because of the life insurance they bought, and your charity nets $1 million because the residue goes to charity. So this is a powerful device. It's a very cool thing that can be used for people selling highly appreciated properties. I've got a slide in here on the foundation. Today, there's lots of ways to create a foundation. If you're Bill Gates, you can go create a private foundation like the Bill and Melinda Gates Foundation, but not everyone is a billionaire, and we can't all afford that. So something called a donor advised fund is an inexpensive, quick, and easy way to set that up. There's lots of groups that do it. You can go all over the place and find it. Legacy Global Foundation is a local organization based here in Arizona. They happen to share an office here in my building, and we know them well. That's something you can consider. And so you get tax-deductible contributions. The money can be invested as an endowment, and grants can go to charities of choice. And oh, by the way, these donor advised funds frequently sell or buy real estate. These are potential clients for you. They are tools that your existing clients may use. They are particularly useful for people who have no children, who want to give money to charity anyway, or who are dealing with highly appreciated capital gain tax issues and want to avoid some of that. And the donor advice fund costs less and gets better deductions than some of the alternatives. So I want to move on from that. So we're kind of approaching a point here where we want to introduce another concept. You are probably familiar with probate, and we'll go back to some of our prior slides to talk about why probate happens. Probate sometimes is a bad word. People hate this word because it is expensive and takes time. The default position is when a person dies, their assets go to probate, and here's why. From the dawn of time, the oldest of human stories tell about people showing up to rip off dead guys. Dead people have no natural defenses. They can't fight back. They don't resist when you steal their stuff. So if you want to steal somebody's property, it helps if they're already dead. And oh, by the way, nobody knows this better than the tax man and the politicians. So if you want to tax somebody, the easiest people to tax are dead ones. They don't vote. They don't write their congressman. They don't march on Washington. They don't rise up in rebellion. So if you want to tax somebody, tax a dead person. So, and probate, by the way, is not a tax. Here's how probate comes into play. Because people rip off dead guys, the people who are rightly entitled to the property are easily exploited or vandalized or ripped off. So to prevent that inappropriate consequence, in our legal system, structures are set up so that when somebody dies, their assets, their properties are frozen. They can't deal with them until they get a court order from a judge saying, this person is in charge and this is who gets the stuff. That, to get any court order, by the way, you're going to court, which means there's litigation. And the kind of litigation involving estates of people that have died is called probate. Now, the good news with probate is that eventually the people that are entitled to the property will get it. The bad news is, again, it's a form of litigation. It's in the courts. It's complicated. It's scary. There's a ton of ways to screw it up. You will encounter this all the time as real estate professionals. Because when somebody dies, odds are there's real estate that's going to be bought or sold. Estates are selling real estate all the time. And by the way, when somebody goes through probate, it's not uncommon for 20 or 30 or 40 letters to show up saying, oh, we're real estate professionals. We'll help you with that probate. So many people do that they must be making money out there as real estate professionals. So that's pretty common. So here's what you're going to encounter. mommy dies and the daughter or the son say, hey, we don't want mommy's house, we want to sell it, but we can't sell it because it's titled in her name. What do we have to do? And the answer is, well, we have to go to probate. So we're going to go to court. We're going to admit the will to probate if there is a will. If there is no will, we're going to have what's called an intestate probate, which means a probate with no will. And somebody's going to be appointed as the person in charge. And most of us know the old-fashioned word, which is executor. And you're only, by the way, an executor if you are a man. If you are a woman, you can't be an executor. You must be an executrix. And most of us no longer know how to conjugate Latin. And so we have adopted a gender neutral term, and that term is personal representative. So in the probate court, the court appoints someone in charge called a personal representative. That person is called or is appointed in a document called letters of appointment. And that's an archaic term. Again, we borrowed it from England. Nobody knows why we have it, but we still have it. We still use it. It's still called that, letters of appointment. Once they get those letters of appointment, then the personal representative can sell the property. They don't have to wait for the probate to end. They can sell it right away. So sometimes if you're waiting on the deal, you got a buyer in the wings, all you're trying to do is get it so that the seller can deliver a good marketable title. You got to get them appointed to probate. So what assets are subject to the probate? And the bottom line is everything not in the trust. So as a real estate professional, once again, part of how you can deliver value to your clients when you're helping them buy that new residence is make sure they take title in the name of their trust. When your customer sits across the table from you and says, and you say, how do you want to take title? In your names as joint tenants with rights of survivorship, as community property with rights of survivorship, or in a trust. And they give you the deer in headlights look and say, I don't know. What do you think? You should have an answer. And your answer should be, well, the best thing you can do is put it in your trust. And if they say, I don't have a trust, then your answer should be, okay, temporarily you can take it in some other fashion, but long-term you should have a trust. Go see a lawyer. And you can give them whoever you want to go see. We would like to be on the list, but we don't have to be on the list. Send them to somebody who knows what they're doing, who can help them get a trust and help them take title to that property in the trust. So that's a value-added thing. Once again, that customer now is going to see you. Oh, you took care of me. You helped me connect with other professionals to help me put my affairs in order so that I'm not going to have all these troubles. When you're in the interim, when they have no trust, let's talk about, go back to that joint tenancy or the community property with rights of survivorship. You know, the rights of survivorship happen automatically when one of the parties dies. It used to be long before there was community property with rights of survivorship that a married couple had no choice if they did not have a trust but to take the property as joint tenants with rights of survivorship. And then they had to prove to the IRS that it wasn't separate property, that it was community property. To avoid that confusion with the IRS and the burden of proving that an asset was intended to be a community asset, Arizona state legislators gave us the community property with rights of survivorship. Now, people will ask you, does this avoid probate? And they'll ask you this a lot, and you should be aware of the answer, because most people think the answer is yes. But the answer is really yes and no. It's both. It does avoid probate on the first death between a husband and wife, but it does not avoid probate on the second death when the survivor passes away. On the second death, that house is still going to be subject to probate, and the kids are going to end up in the courtroom spending thousands of dollars in a year of their time dealing with a probate. By the way, the same is true with joint tenancy owned among people that are not married. The three siblings or the three best friends from high school own a property together, as joint tenants, and as they plink off one at a time, pop, pop, and the last one is standing, owns the entire property. Probate was avoided on all of the deaths except for the last one. When the last one dies, there's gonna be a probate. So sometimes you'll talk to these people, and maybe they're selling their house, and you go, well, do you own any other real estate? By the way, that's a question you should always ask. What other real estate do you own? Oh, well, I also own a cabin with my brother. Well, how do you own it? Oh, we own it as joint tenants. Well, what's going to happen when one of you dies? Well, the survivor gets it. Well, is that what you want, or do you want your children to get that? Oh, well, wait. Yeah, I would like my children to get my half of that cabin. Well, then joint tenancy doesn't work. By the way, that's an example of when an LLC owned by that brother and sister, 50-50, with each of their 50% interest owned by their own revocable trust, owning that family cabin, so that then there's automatic succession issues and the family cabin stays in the family. How are we doing? Does anybody have any questions? We've covered a lot of ground. We would like to open it up to questions. Unmute yourself and ask it or type it in.
I think while we're waiting for them to do that, just one other thought. The Arizona statutes state that probate is required when you have equity in real estate over $100,000 and personal property valued at $75,000 or more. So just something to keep in mind when you're talking to your clients about whether or not they may or may not be subject to probate.
Yeah, and with probate, by the way, we do a lot of those. Candidly, we try to help our clients avoid them where possible by having a trust and having the trust funded, or having appropriate title to property with beneficiary deeds with smaller estates. So maybe they don't need a trust, but still a beneficiary deed is appropriate. But at least half of the people out there, when they pass away, don't have a trust, don't have proper succession devices in place, and so their estates end up in probate. And that's a place to pick up bargains. I've seen probates where with one escrow, a property gets flipped even more than once. The personal representative sells it to the first flipper, who sells it to the second flipper, who sells it to the third flipper, each time adding a little bit to the purchase price. So we're going to unmute you all and invite comment right now. Any comments or questions?
I think you can bring them up on the screen too. Oh, they're there.
Oh. No questions. Is it that boring? You know, we took our time going through some of those things, and maybe we should come back to that. But I want to come here once again and hit.
Hello.
Yes.
This is Alicia Quinto. As you were talking, I was thinking of a host of my clients that I could have and probably should have advised about this over time. You know, single mothers with both grown and minor children, or couples that are aging that have adult children that they still help. I mean, this is kind of a universal kind of issue where people do want to preserve their assets. Let's say this is just not an area that I have any experience in. Let's say that I did want to refer some of my clients to you, but either before or after a transaction final. What should I do?
Great question. First of all, because we have a professional collegiate relationship, that initial consultation with you and your client is complimentary. We're not going to charge. Also, before you even refer them to us, it's okay if you call or email and run the scenario by one of the lawyers here. Hey, I have this client situation. Is this something that that you can help with? Is this something that they need what you do, or not? And so you can find out, because sometimes we'll say, yeah, we'd love the business, but we really can't help that person. But so you can talk to us, you can consult with us, you can brainstorm. Sometimes the clients are not going to be willing to meet with us but they will talk to you, and you can go back to them and say, you know what, here's what you ought to do. But if you do want to, and if the client is willing to meet with us, the best thing, and I'll tell you how not to refer, or how at least it's ineffective referral and the best way to refer. If you give them our phone number, odds are they're not going to call us. They just won't.
Right. Yeah.
Just like if we give them your phone number, they're not going to call you either. So if possible, the best way is, while you're with the client, say, let's call them right now. And you call our office, and you'll get our front office. We have 2 or 3 people who work there that's their job, is to take these calls when they come in and schedule a meeting. And you can say, I'm here with Mr. and Mrs. Client, or with Mary Client, who's a single mom, and she's got a house and she's got some kids, and she needs some stuff. What can we do? And they'll schedule a time. And in this environment today, we can do a Zoom conference just like this, if for whatever reason they can't or don't want to come in. If the shelter-in-place restrictions are lifted and we can visit in person, that's great. By the way, legal services, like what we do, are an essential service. We have a small office. We're still open for business. We have people come in, and we keep social distancing. We can sit across the conference table. We don't touch each other or share pens. So we can still visit personally. But we have a lot of people who will visit just like this over Zoom. That first meeting is complimentary. We're going to identify their family situation, their assets, their needs, their concerns, their goals. And in most instances, we will map out a proposed plan. We'll say, based on your situation, you need A, B, C, D, and E. And in most situations, we'll be able to give them a hard quote. If you do this, it's going to cost X. And then they can go home and they can think about it. And candidly, some people engage us and some don't. And some people engage us right now, and some people take 2 years to think about it before they engage us. And we're okay with that. We're okay with those who say, wow, this is scary and I want to go home and think about it. Let's talk about costs. Typically, if it's very simple, we're just doing a beneficiary deed, $300 or $400, and they can get that done. If they just need those basic documents, the powers of attorney and living wills and a will, so they can say who gets the minor children, they're going to typically spend between $800 and $1,500. Less for a single person, more for a married couple, because it's more complicated and there's twice the documents. If they're doing all those basic documents and a trust, the entry level is about $2,500. Sometimes that's discounted for very simple small estates, but typically it's about $2,500. If their estate is bigger, like more than $1 million, but less than $5 million, typically it's going to end up being about $3,500. If they're a large estate, which arbitrarily, roughly about $5 million, they could spend as much as $5,000 on the trust. And that's for the trust and the basic documents. An additional cost, and I want to walk through this because this is critical, is the funding it, deeds. If we do the deed, we charge $200 a deed. And then the recording fees, which hover in the like $48 roughly. We just had a client, in fact, 2 days ago, I met with a client who has 8 timeshares that are deeded. And they're deeded in a state where you can't just do a simple deed. there's a mountain of paperwork with every single deed. And so in that particular situation, our cost to do that deed is about $500 a deed. So his trust was cheap. Funding the trust was the most expensive piece. And in that particular situation, I said, look, you might want to go back to your title company or to the timeshare company and see if they can do those deeds for cheaper than we can. And so we can knock the price down. We won't do the deeds if you get somebody to do it cheaper, but if we have to do it, we have to charge us because it's just dang stinking complicated. So sometimes with real estate professionals, if they say, hey, no, I'm working with one of you guys, and can you get the deed done? If you can do it, more power to you. I'm happy to let you do that. Frankly, at $200 a deed, it's a loss leader. We don't make money on that. It barely covers our paralegal time and the resources it takes to do that. So I'm happy to let somebody else take care of that piece. What I want in those circumstances, though, what we need to have, if you or the title company you're working with is going to do the deed, we just want confirmation. When you're done, please email us a PDF of that recorded deed so that we can mark our diagram on the diagram that we showed you here. If I can come back to that, we can mark our diagram. And let me see if I can get this slide to play. Yeah, here. So we can mark our diagram. You can see right here, we've got that little green check box, the green, when was the deed done? We'll actually note the date. A deed was done on this day and it was recorded, so we can confirm it happened. If it hadn't happened, we'll put a little flag on there that says, hey, this hasn't happened yet. We don't know it's happened. And so 2 years from now, we're going to ask your client, hey, did you ever get that property deeded in there? Can you give us a piece of paper to demonstrate that so that we know it actually happened and isn't just flapping in the wind? If people are going to do complex planning like this with lots of entities, I would say, because people, what's it going to cost? Entry level, they're going to spend at least 8 to 12 grand. If they're a guy that's buying and selling a boatload of properties and they've got tons of entities, you can spend 25 to 100 grand. We've had real estate developers that come in and say, yeah, I've got 80 properties in 50 LLCs, and they're in 19 different states, and they're all messed up. They're all in my personal name, and they're all messed up. That's complicated, and they're going to drop some coin to get it fixed. But at the end of the day, it's worth it, because otherwise you could have probates in 19 states. So the cost of not doing it is more than the cost of cleaning it up. So we will help the simple, small, just a single mom who just needs to have a will, so who can get her kids. We can help that person. To the mega client with a bajillion properties doing all kinds of stuff and everywhere in between. We have a broad base of a bench. Michael's here. We have another attorney's here that handles the full range of all these. I guess I'm going to say the third. So the two options: give them our phone number. Doesn't work very well. Schedule the meeting in their company as option number 2. Option number 3 for the referral is get their permission for us to call them, and then give us their phone number. So if you say, look, I want you to talk to Michael or Rick at Durfee Law Group, are you okay if I give them your phone number and have them call you? And if they say, yeah, well, then call my front office and say, I'm here with Mr. and Mrs. Client. Here's their phone number and here's their names. They're expecting your call. Right away, one of our people in the front office, or the office manager or one of the paralegals will call and say, hi, Mr. and Mrs. Client. I'm calling on behalf of Mr. and Mr. Durfee and Michael Koberlein at Durfee Law Group. You were referred to us by so-and-so, Loretta, or whoever, and it's our understanding you'd like to have a complimentary consultation to explore whether or not you need some estate planning. Okay. Other questions or comments?
just to interject something by way of clarification, with respect to probate, the requirements are based on whether the person who has passed away, the decedent, if they have real property that has equity in excess of $100,000, then informal probate is required. Informal probate is required. And the other part of that is if they have personal property in excess of $75,000, then probate is also triggered. So if they have a bunch, if they have the boat and they have a car and they have other things of value, gold and silver and things like that, that are in excess of $75,000, then that can trigger probate. The $100,000 side of it is just attributable to real property.
So I'm going to tell you a story. Years ago, I had a woman come to me. Her husband had passed away, and there was some real estate in his name alone, not in their name as a couple. And we had to do a probate. And as we went through the probate, we did something that's actually customary. We did an asset search. We went looking for stuff. And we found a very expensive, at the time, $70,000 Mercedes-Benz that we didn't know about, and that, in fact, the wife didn't know about. And I called the wife, and I said, so I have some good news and bad news. And she said, well, give me the good news first. And I said, okay, well, we found another asset. There's another $75,000 asset in the estate. It's a Mercedes-Benz. Did you know your husband had it? She said, no, I didn't know that. She said, what's the bad news? And I said, the bad news is the car has been parked in the driveway of a very attractive 23-year-old woman with whom your husband was having regular liaisons. And she said, if he wasn't dead, I would kill him. So people often have assets they don't tell their spouse about, or they don't know about, or they forget about. Another thing we encounter on a surprising regular basis is we've had clients we've worked with for decades that will say, one day they'll drop in conversation and say, oh, well, what about the thus and such property? What about the shopping center in Peoria? What about the cabin in Sholo? What about that Wyoming property? We'll go, wait. I'm looking at your schedules of assets here, what we have in the trust. I'm looking at your diagram. We don't know anything about that. And then we'll discover, oh yeah, they have this asset over there and it's not in the trust. So it's real easy for assets that should have been in the trust to get left out. Another common thing that happens that real estate professionals ought to be aware of that gets touched, and we kind of touched on this earlier, but we didn't flesh it out. When people are refinancing a personal residence, sometimes to make it easier for the lender, we pull that residence out of the trust, we retitle it in their individual names so they can get the financing quickly and easily, and they intend to put the property back in the trust, and then they don't. That, in fact, is the most common reason for probate with people that have trusts. Is at one time the property was in the trust, but we took it out for some temporary reason, and then failed to follow through and didn't put it back in, so now we have to probate it. So when you're working with people like that, it's important to help them complete that final step. Another interesting thing, by the way, that a lot of people don't know is with debt on a personal residence, if it's a purchase money loan on a personal residence, so a mortgage that you get when you buy the property to move in and live in it, that first loan that you get. In Arizona, lenders are not permitted by law to ever pursue a deficiency judgment. So if the property was worth whatever, you got the mortgage on it, and then we have a market crash and the property's underwater, the bank's recourse on that purchase money loan for a personal residence is limited to recovery of the property. With a non-purchase money loan, even on a personal residence, the lender could hypothetically pursue a deficiency judgment. So personal residence, we had a first mortgage that we got when we bought the property. We kept the property, but we refinanced it to get a better rate. Now that new mortgage is not a purchase money loan, it's a refi. And then if we have a market crash like we've seen happen every 10 or 15 or 20 years in the last several decades, and that property goes down in value, now it's a non-conforming loan. The bank calls the loan because they can and because they have in the past. And the homeowner, the borrower, defaults and the bank takes the property, and the property was worth more, or excuse me, the debt on the property was more than the value of the property. That the lender could sue the homeowner for a deficiency judgment. Now, I have never seen that happen with a small home. I have seen it happen with the big mortgages, with high dollar houses that, gee, it was worth $2.2 million and you got a $1.8 million loan, but now the house is only worth $1.2 million. We have a $600,000 deficiency because you refinanced it. I've seen the lender go after people on those big homes. That's something else for you to be aware of. We're at a point where we can keep making stuff up. We've covered all of the items on our agenda. I'm happy to stay online and answer any questions, but if the class is done, if our cup is full, we can excuse people and let you go. Are there more questions or comments or things that you want to hear about?
Yes.
Okay, I heard a yes. That means somebody's got it. Bring it on. Or was that, yes, we get to go home early? You're probably already home. Okay, I'm not hearing anybody come up, so absent questions, we're done. Let me conclude with this slide. I hope you can see it still. Something that distinguishes dynasty estate planning from run-of-the-mill regular estate planning is that we look beyond what happens at the point of death. Traditional estate planning is typically focused on, well, what happens when somebody dies? Who's going to get their stuff and who's going to be in charge? With dynasty estate planning, we ask, well, okay, then what? Odds are most people don't inherit anything until they're at or near retirement. We're older when we inherit. We've raised our children, we've had our jobs and our careers, hopefully we've paid for our homes. If we've had a 30-year mortgage, we've had 30 years to pay it off by the time we get that inheritance. So when an inheritance comes, if we consume our inheritance, we eat it up and dissipate it and distribute it out and it's gone, we screwed up. But if we can preserve that inheritance so that it's protected and it grows over time, it can get bigger and bigger and bigger from one generation to the next. Families that understand this idea 100 years ago started with less than $1 million. And today, 4 or 5 generations later, have billions of dollars. And incidentally, families that understand this figure out that how we give our wealth to future generations has a gigantic impact on what it does to them. If we give it to them in the right way, in a way that is protected, we can help those generations, those future generations, become highly effective, powerful, productive, honorable, worthwhile human beings that make the world a better place. If we give it to them in the wrong way and at the wrong time, we turn them into unproductive, lazy, trust babies that feel entitled and wonder why the world isn't giving them a better deal and blame everybody else for their problems. But we can have the money be a good thing and not a bad thing, and we can have more instead of less. And that kind of planning to turn the money into a good thing instead of a bad thing and to make it grow over multiple generations is what we call dynasty planning. And again, that's a concept that families 100 years ago that figured this out today have enormous amounts of wealth. And part of what we try to do is help our clients catch that vision and put tools and planning devices in place that will empower their families to build and grow wealth in a multi-generational fashion on purpose. By the way, multi-generational wealth never happens accidentally. It's always deliberate. There's always intention to do that. And conscious, articulated intention. It's spoken about. It's talked about at family dinner and family gatherings. How are we building our family, not just financially, but in all other respects as a family? So that's all these little tools, the basic documents, the wills and the powers of attorneys, the LLCs, and those are tools that are important, but they're not the real thing that drives what happens here. The real thing that drives what happens here is helping families build and grow and be strong as a family over multiple generations. So we have the right tactics when we know how to climb the ladder and get from the bottom to the top without hurting ourselves. We have the right strategy when our ladder's leading on the right wall. It's not on the wrong wall. And we are employing the right logistics when we get the right ladder to the right wall at the right time. And that's what we want to do. We want you to be a part of that team. You as a real estate professional are crucial to identify, hey, you're climbing the ladder the wrong way. You really got to get that house in a trust. Hey, your ladder's on the wrong wall. You've got joint tenancy, and yes, it avoids probate on the first death, but not on the second death. And by the way, do you really want your brother to get everything and disinherit your children? And hey, yeah, you got to trust, but and you're buying and selling stuff. Let's get it all the toys in the toy box. Let's get it all put together. So you, as a real estate professional, play a crucial role in delivering that to your clients. And I want to come back to the very beginning here and re-emphasize this initial point that being aware of these kind of issues helps you get more clients. It helps you get the kind of clients you want. It delivers better service to the client. It protects the client from getting injured by doing something silly. And you will thrive and prosper as a professional by helping other professionals thrive and prosper. That's what we try to do. We want to help you in your business, help you succeed, help you take good care of your clients. And with that, again, one last chance.
Rick, this is George Bliss. Just wanted to thank you for the session this morning. This has been very informative. I'm sure all the people enjoyed it.
Thank you. We appreciate the opportunity. It's kind of fun to do this with Zoom.
You bet.
We've done a ton of personal things like this, and we kind of miss if we were face to face. My experience has been there would be more questions and there'd be more comments.
Indeed.
So, but it's fun to do it this way. And I look forward to meeting all of you professionally and wish you the very best in your growing and thriving real estate professions.
Thank you, Rich.
Yep. Thank you, everyone.
Thank you.
Thank you. And I'm going to sign us off here.
Thank you.